perhaps would have been a valid point if the party president was the sole repository of the decision making with respect of the policy and administration of the party. For analyzing the said submissions, a perusal of the SS Constitution was made. The SS Constitution provided that Rashtriya Karyakarni shall be the highest authority of the party, and its decision in all matters concerning the party policy and party administration shall be final. It is also to be noted that the Paksha Pramukh is only a presiding member of the said highest authority in the party and in no way is the sole repository of decision making in the party. Thus, in view of the same, the submission that the decision and or the will of the Paksha Pramukh is synonymous with the will of the political party cannot be accepted. It would be appropriate to note that the SS Constitution does not even have a post called Paksha Pramukh. However, it was argued by the UBT faction that the nomenclature difference in the 2018 leadership structure and the SS Constitution is not a relevant factor for the purpose of deciding the preliminary issue. Even though I have held in paragraph 117 that 2000 leadership structure is not at all in conformity with SS Constitution, I shall consider this submission. The Constitution of Shivsena provides for Shivsena Pramukh. The submission of the petitioner that Shivsena Pramukh mentioned in the SS Constitution is the same post of Shivsena Paksha Pramukh termed in the 2018 leadership structure. By relying on the powers of Shivsena Pramukh, it was argued by the UBT faction that he is the authority under the party constitution vested with the powers to remove any member of the party. Thus, it was further argued that an authority who is vested with such power of removal reflects the will of political party with respect to removal of members from and for anti-party activities. However, a complete reading of the said provision in the party constitution reveals that the said submission is factually wrong. The said provision in relation to the powers of Shivsena Pramukh clearly provides that such a power is not absolute and it has to be exercised in consultation with the Rashtriya Karyakarni. Further, it has to be noted that such a power is only available to the Shivsena Pramukh for the purpose of removal of members mentioned in Article 8, Schedule B of the said Constitution. The said schedule does not deal with leaders of the party. Leaders of the party is given under Schedule A of the said article. Thus, Shivsena Pramukh does not have any power to remove any leader of the party. Thus, the submission of the petitioner that Shri Uddhav Thackeray, Vide, letter dated 30/6/2022, had removed Shri Eknath Shinde from the post of Shivsena leader cannot be accepted as such power are not vested with the party president. Hence, on this ground also, the submission that the decision and or the will of the Paksha Pramukh is synonymous with the will of the political party cannot be accepted. If this proposition is accepted, then in a situation where the party president, who is also a legislator, itself defects, then he could simply escape the wrath of the 10th schedule by pleading that his decision is the will of the party. Further, if this proposition is to be accepted, it would mean that no member can ever voice concern against the party president, and the party president might possibly be able to seek disqualification against any member who questions his credibility. This would run contrary to the concept of intra-party dissent. In view of the clear and unequivocal finding of the Honorable Supreme Court at paragraph 183 to 190 of Subhash Desai, I will be falling foul of the judgment of the Honorable Supreme Court in Kyoto Holohan, wherein the constitutional validity of the 10th schedule was itself upheld on the grounds that it is not an anti-dissent law if this proposition is accepted. I shall now proceed to consider whether the will of the majority leaders in the 2018 leadership structure is synonymous with the will of the political party. An alternate submission was made that even if the Paksha Pramukh is not accepted as the repository of the will of the political party, the decision of the leadership structure has to be construed as synonymous with the will of the political party. This proposition is also devoid of merit, and I do not find any substance in it for following reasons. In a circumstance where there is no dispute amongst the leaders identifiable by the constitution of a political party, the proposition would have held water. However, the factual matrix of the present matter is different. This is a matter where there is a dispute within the leadership structure itself. It is to be noted that in the present matter, rival factions have emerged in the legislature party, political party, and thus inevitably amongst leaders of the party as well. Thus, it would not be wise to apply this proposition in the present matter. The existence of split-stroke rift in the leadership structure is admitted by the petitioner and/or the UBT faction, as can be inferred from the petitioner's affidavit in lieu of examination in chief of PW1, petitioner himself, that the leader of the UBT faction did not have the support of all the members of the 2018 leadership structure when rival factions emerged. Thus, the submission that the decision of the leadership structure has to be construed as synonymous with the will of the political party could have perhaps be applied in a situation where there is a dispute between some members of the party and the elected leadership. In such a case, the leadership of the party could have possibly taken the stand that their decision would have to be taken as the decision and will of the political party until they are so removed from the leadership structure by a mechanism recognized by the constitution of the said political party. However, as I have noted earlier, in the present matter, rival claims have emerged wherein the leadership structure about the leadership within the leadership structure about the leadership itself. In such a situation, one leader's contention that his will is the will of the political party would be contradiction in terms. Thus, when there is a vertical rift in the party and two factions within the said leadership structure emerge as a result of the said rift, leaders of either faction, both Shri Uddhav Thackeray and Shri Eknath Shinde, could equally claim to represent the will of the political party. In that case, it would not be appropriate to take their decision as the decision that carries the will and wish of the political party when the question of which faction is the political party is being considered. There possibly lies one more aspect which could be considered. Does the stand/decision of the majority members of the leaders within the leadership structure, identifiable and appointed according to the constitution of the political party, could be construed as the will and desire of the political party in the event there is a dispute within the leadership structure?